and at least 2 others were convicted of unaliving people. All these aliens have been tried, they've been convicted in a criminal court, and they were already adjudicated to be removed. And the district court's aggressive enforcement of them caused severe harm to us. And the Court of Appeals declined to hear any of this, and so Supreme Court, it is time for you to do something. 10 days? Like, you need to sit on it, you need to read some books and journal on it, go like on a long walk on the beach, use alien, pray about it. Am I claiming to get tortured? Ridiculous. The Trump administration has had about enough. They're demanding the Supreme Court finally take action on this illegal alien deportation battle that we've been covering here for quite some time. And they sent this one in to the United States Supreme Court from D. John Sauer. They said, hey, we need a stay of this lower level judge out of Massachusetts, this Murphy character who's a strange judge who says Trump has been ordered to bring these people back. They're illegals. They had plenty of process. They had final removal orders and they were removed. And this judge says, well, I really like that one guy. And so can you bring him back? Because I'd like to talk to him privately. And so we're asking ourselves what's going on this. And now we're going to the Supreme Court. Now, Pam Bondi gave us a little announcement on this and said, you know, here's why we're doing this. The invasion of illegal aliens must end. And the conduct of our nation's foreign policy cannot be directed by a single weird judge in Massachusetts. The DOJ has asked the Supreme Court to intervene to stop this insanity so that President Trump can continue to deport the worst of the worst illegal aliens. We will continue to defend President Trump's lawful authority. He's not making it up. He got elected to the presidency to make America safe again. And what's happening is, by the Supreme Court allowing this stuff to continue, we have dead Americans who are just going around jet skiing like Ava, who was killed in Texas. So the Supreme Court, there is actually an urgency to this. If you're paying any attention, John Roberts and Amy Coney Barrett, we're tired of our people being killed by illegals. So stop the insanity. Chad Mizell is coming out and supporting Pam Bondi as well, saying the Supreme Court must put an end to judges usurping the president's foreign affairs powers. As explained in our brief, convincing third parties to accept these people is a big deal. And these aliens are now being protected by a single court judge called Judge Murphy in Massachusetts and Judge Zenas in Maryland and the rest of them. These are aliens being protected. One alien was convicted of abusing a child for most of a decade when the child was 7. Chad Mizell for the DOJ, chief of staff there for Pam Bondi, explains. Another was convicted of abusing a mentally handicapped woman with the mental capacity of a 3-year-old. What? He's not working on his PhD scholars and working in the fields farming for America? And at least 2 others were convicted of unaliving people. All these aliens have been tried, they've been convicted in a criminal court, and they were already adjudicated to be removed. So one single weird federal district court judge has now stalled these efforts nationwide, and we're sick of it. Here is what they sent into the Supreme Court. They write, listen, John Roberts, Amy Coney Barrett, wake up. Pursuant to the rules, we are now in your court. We've respectfully filed this application for a stay of the lower level judge Brian Murphy's decision out of Massachusetts. We're also appealing this to the First Circuit, and we need you to do something on this. Given the urgency of the circumstances and the government's ongoing irreparable injury in our affairs, diplomacy, immigration, foreign policy, we request an immediate administrative stay because this case addresses the government's ability to remove some of the worst illegal aliens that they want here. They want to have them have another set of due process hearings. They already got a set. Americans don't get to have multiple trials if they don't like the outcomes, but illegals do. That's the standard that they want. The United States is facing a crisis of illegal immigration. We've got dead young Air Force cadets being murdered by illegals running away, fleeing the scene. In no small part because many aliens most deserving of removal are often the hardest to remove. They don't go easily. When illegal aliens commit crimes in this country, they write to SCOTUS, they are typically ordered removed. Pretty obvious. But when those crimes are especially heinous, their countries of origin are often unwilling to take them back because they deported their murderers and their child abusers and those who abuse the mentally handicapped. They get them out of their country, so we got to deal with them. And then we have psycho judges who say, don't be a bigot, Rob. You should accept them all. As a result, criminal aliens are often allowed to stay for years on end, and they victimize law-abiding Americans in the meantime. Now, the executive branch, President Trump, empowered by the American people, has taken steps to resolve this problem by removing aliens to third countries who've agreed to take them. Convincing third countries to take these maniac criminal monsters requires sensitive diplomacy, I'll bet. Until recently, those efforts were working. And then just last week, the government was in the process of removing these criminal aliens who had been in the country for years and decades after already getting final orders of removal. Despite having horrific crimes, they said you can't leave them out. These aliens, including one who was convicted of abusing a child and another, a mentally handicapped person. 2 others, unaliving individuals. Now, all these aliens had already received extensive legal process, so stop your crying that they didn't get a hearing. All were tried and convicted in a criminal court. Those are the Article 3 courts they keep lecturing us about, with all the process and protections afforded to criminal defendants. All convicted, all adjudicated removable. But a single federal district court judge has stalled these efforts nationwide because he really wants that one dude back in his chambers. On behalf of a nationwide class of aliens with final orders of removal, the district court issued an extraordinary preliminary injunction that restrains Homeland from doing its job, even though the statutes say they can, unless they set an onerous set of procedures to assess any claims under the Convention Against Tortures. Now, those judicially created procedures are wreaking havoc on this process. In addition to usurping the executive's authority over immigration policy, the injunction disrupts sensitive diplomatic, foreign policy, and national security efforts. Here's how it works. Recent events, Supreme Court, wake up, vividly illustrate the injunction's pathologies and what they're doing to wreck America. Here's what happened. Last week, the lower level court required the government, don't send these people to the South Sudan. They did so by exploiting an open-ended term in its injunction, saying the government did not give them a meaningful opportunity on any of this to raise a fear of torture concern in that country, right? So the judge says they get a second bite at the apple, open it up, then they can reclaim that they're afraid of being tortured in the South Sudan, and so they can't be removed. They all did get notification. None expressed any fear at any time or even on that day. They said, hey, we're removing you. Are you afraid of anything? No. Great. Get on the airplane. Judge said that's not enough time because they didn't have an opportunity to talk to the ACLU lawyers, and the ACLU lawyers would be the ones who could explain to them that they have to be afraid because they're going to get murdered in the South Sudan or something, and drag out of them, create a whole new claim. The judge wants that meaningful opportunity to be access to Democrat lawyers. Having slammed on the brakes while those aliens were literally in mid-flight, they forced the government to then detain them at Djibouti, not designed or equipped to hold these monsters. Then the court retroactively clarified its injunction to oppose an additional set of intrusive and onerous procedures on Homeland. And as a result of that, the United States has been put in this intolerable choice. We have to either do one of the following. We have to either hold these aliens for additional proceedings at a military base on foreign soil, you're requiring this, where each day of their confinement risks harm to American foreign policies, or we got to bring these people, these convicted criminals who are not citizens, back to America. That's the judge's decision. Is he like representing illegal alien criminals? Most tellingly, the injunction creates a diplomatic and logistical morass that the Secretaries of State and the Secretary of Defense, Hegseth and Rubio, told you is causing significant and irreparable harm. But in addition to being misguided here, these court-ordered procedures from the judge are also unlawful. To issue its injunction, the lower-level judge disregarded 3, count them, separate sets of jurisdictional bars that stop the courts from doing this crap, including to preserve the primacy of the executive branch. The court didn't care. Having done so, the court wielded its own subjective, quote, sense of fairness, and they quote it because that's what came out of the judge's mouth, under the guise of due process. Well, it's not fair that they're going away, and I hate Trump. Second guessing the Trump executive branch about removing aliens whilst trying to comply with claims against torture obligations that were already validated. They're not afraid. Get on the plane. These are judicially invented policies, and the district court's aggressive enforcement of them caused severe harm to us. And the Court of Appeals declined to hear any of this, and so Supreme Court, it is time for you to do something. Now, here's how this works. The law, called the INA, it says the executive branch handles these, okay? It's not Article 3, it's Article 2, because they're illegal aliens, and the executive branch enforces the law. And they broke the law entering the country illegally, so they don't get access to the same court system. It's not me saying that. Trump didn't make this change. It's the Immigration and Nationality Act. It's how it's been forever until now. The INA gives the executive broad authority to remove aliens to various countries. Obama removed a ton of people. Clinton removed a ton of people. Now that Trump is doing it, now they're saying, well, it's illegal. Give them access to the courts. It's a judicial coup. They're trying to get more power than they have, and the Supreme Court is enabling it. Of course, under the statute and regulations, the executive will not remove an alien if they're going to be tortured over there. And so there's provisions here. Now, while the INA authorizes the executive branch to remove them, it's also silent to the process that they must get. So we establish a framework, says Homeland. We established a 2-track system to address these people who've been ordered removed, and we've got sufficient assurance they're not going to be tortured down there. You know what we're more concerned about? Our citizens being tortured by these illegals who are exploiting children and abusing people who are not mentally well. That injunction runs afoul. The judge said, you can't remove anybody, right? So the judge came, said these gangbanger illegals are now a class. They all get special protections, class counsel, ACLU lawyers, and they said you're violating their due process because they didn't get lawyers to come in. It enjoined the government, said you can't remove anybody, and then clarified saying don't take them out. Now that injunction runs afoul of multiple bars to this judge's jurisdiction. He has no power over this case. First, this section of the law prohibits federal courts from issuing class-wide relief under the INA. Specifically, it says injunctions should not be happening. Now, it's irrelevant that this court relied on a provision that's not in there to justify its injunction, but the law says you can't issue it. Now, in addition to this, the immigration laws literally and specifically strip this judge and these courts of jurisdictions to review the claims. So Homeland says, are you afraid? He says, no, I'm not. Great, get on an airplane. The judge can't substitute the judge's opinion on that. The judge is saying, I didn't. The judge is just saying, well, I'm just substituting the amount of time. I just gave them more time to investigate this. Of course, they're all going to have claims suddenly once the lawyers come in. But it strips them. You can't substitute your judgment. Homeland gets the benefit of the doubt because it's an equal branch of government. It's actually much more powerful than the judiciary is trying to seize power now from the executive. Both sets of these bars apply here. They're demanding greater process for their claims, right? They want due process premium in America. You get pulled over driving without a license, your car gets impounded. You get arrested for driving without a suspended license. Kilmar was allowed to go. He's an illegal. He was trafficking human beings. If you were trafficking human beings, you go to prison. He gets a call from the FBI, nothing. So they get more than you would get. You lose your speeding ticket trial. You think you get another one in a different court because your due process was violated? Get out of here. That's hilarious. Tell due process to a speeding ticket judge anywhere in the world. You give this judge an illegal who is abusing a 3-year-old, and he says, yeah, that due process is pretty important for them. Now, the district court held itself above these limits, ignored the law completely, and then substituted his opinion in. That is no way to read any statute, but especially not this. And also, this judge's analysis is fatally flawed. Without any mooring in law, because he just loves illegals, it's really a bizarre thing to read in a writing. Like, this is weird. It doesn't even sound like a judge. The district court revised the government's policy to better comport with the sense of fairness. It rejected the government's approach in utilizing countrywide assurances as to the treatment, instead insisting that there were individualized assessments, right? Every single one of them gets to meet with the ACLU lawyer. But as this court has made clear, the Supreme Court, not this lower level judge, the judiciary is not suited to second guess the determinations that we establish. And they also then, the judge made up this whole new thing. It says, okay, now they get 10 days to raise a claim. No, we gave them 2 hours. Here's the thing. You're going on an airplane. Do you have a claim of fear? No, you don't? Okay, fine. Then get on the airplane. If you do have a claim of fear, well, then we'll process you. We won't put you on the airplane. But they didn't. They all got on the airplane. The judge wants 10 days. Again, this is specifically so that the lawyers can come in and file a claim on their behalf. Just talk to their clients. Is somebody attacking your pupusas down there? Moms of pupusas getting obliterated in the South Sudan? All right, yeah, that's what we thought. Yeah, pupusas. No, it works. Or if you're a gay man and you're walking down the street and somebody looks at you strangely, maybe that is intimidation too. This judge will buy that too. So whatever you want, they'll just make something up. Then if there's an adverse finding, if they say, I'm a gay man going to be looked at weird in my pupusa business, then what they'll do is say, that's not enough. Okay, go make your pupusas. You're going to be fine. That's not torture because you get scolding looks. Deal with it. They'll turn around and say, then they get 15 days to appeal that finding from Trump. Oh, no. We think that was a real serious issue there. It typically takes minutes, not weeks, okay, for an alien to express fear of being tortured. Hey, you're going to the Sudan. Are you worried about this? Yes. They're going to, pupusa me to death or whatever. All they got to do is raise the claim. They didn't. These arbitrary deadlines, which add 25 days to the whole process, are out of step with other immigration law because the judge is just making it up. Now, all of this is particularly unjustifiable because many class members are aliens who have never been admitted to the United States. Therefore, they don't have due process rights to any additional removal proceedings beyond the ones that the political branches have provided. They're not citizens. The Supreme Court talked about this in DHS versus Thoracciagiam back in 2020. But what this judge did and his injunction is jeopardizing public interest. The injunction prevents Homeland from efficiently removing any of these aliens. It delays third country removal by at least 25 days for every single person who raises a torture claim, no matter how frivolous it is. Given the practical realities that this court neither appreciated nor acknowledged, the consequence of these delays are that ICE is going to have to restart the entire removal process from the beginning. They're going to have to freeze things as the government is trying to rework arrangements with foreign countries because now we're on a 2-week delay. That's the whole point. Judges trying to break the system. Meanwhile, the very aliens whose removal is most urgent will be allowed to remain in the country and will often be released, given the limitations in legal requirements, much to the peril of law-abiding Americans who just want to go go out to the lake with their daughter and not be attacked by two illegals crashing into them, murdering their kids. The district injunction also causes severe ongoing irreparable harm to the government and, of course, to us, the American people. But what does this judge care? He's not elected at all. Finding third countries willing and able to accept aliens is a delicate endeavor. By interjecting itself in this process, the judge has become the president, wrecking those carefully negotiated arrangements, causing major and irremediable harm to U.S. foreign policy. Rubio even said that to you, Judge, and he is the duly appointed Secretary of State. Moreover, the injunction's open-ended terms allow the court to continually move the goalposts as the judge is now the president, as illustrated in the recent clarification that its original command said, right? His original order, like the judge, is just terrible too. He says, give them a meaningful opportunity to contest it. They said, great, we give him a full hour. Like he gave him the document, sat him in a room, no distractions, in multiple languages, read it. Are you afraid you're going to be tortured? No. Okay, great. You need any more time to analyze it? No. Okay. But then the judge says, you did, that's not what I meant. That's not a meaningful opportunity. I wanted him to have a whole slew of lawyers from the ACLU come in here and have a cup of tea with him. Together, these onerous burdens impede the government's ability to do anything. Now, by contrast, the respondents, the gangbangers, and the lawyers cannot establish any irreparable harm to them. Okay, all members of the class, they've already been adjudicated and ordered by a judge to be removed from our country. And all have already had the opportunity to raise their claims about torture. Now, the injunction adds new hurdles to the process that we've already decided to offer. In circumstances where valid concerns about torture are notably unlikely to arise, how are they going to be tortured in this third country if they were never there before? No one even knows them. No one cares about them. Moreover, Homeland and their policy is similar in timing to other expedited removal processes that have already been upheld. The Supreme Court did it in this case called Thur ACGM, and it guards against the concerns about torture. We're concerned about American torture. They can go. The district court invented, and this new process is just delay. Certain aliens may benefit from stalling their removal, no doubt, but the nation does not, and we're absolutely sick of it. The INA authorizes the removal of these people. INA. And that was passed a long time ago. This was not Trump. This is all the law. They're dumping all the rules in here. Claims against torture doesn't alter whether an alien may remove. It just goes to where an alien may be removed. All right. So we're not going to send you to Guatemala because your parents are there, Kilmar, and their pupusa business is still under attack. No problem. But we'll send you to El Salvador. You're not a citizen there. You may not want to go there, but there's no claim against torture down there. So El Salvador is perfect. Now, this is saying that it only stops them from going to a specific location. On his first day in office, Trump came in and declared that millions of illegals are a threat to national security. That's why he got elected, in large part. To fix this, to combat this, the president directed Homeland to take all appropriate action to detain and remove aliens who had been ordered removed. So then we issued guidance at Homeland on February 18th. We went through, we said, we're going to review cases and determine who can go. And if they have some sort of claim, we're going to send them to a different country. The INA does provide for third country removals, but it doesn't delineate a particular process. So we issued our own guidance on this. We created a policy, distinguishes between good countries and bad countries, and implemented the policy. And it's all in accordance with our laws and rights to execute the policies since, you know, we're running things. So here's some more factual background on this case in specific. The respondents are 4 illegal aliens subject to final removals. They each include and allege that there are valid reasons to fear removal to specific countries that were not included in their removal orders. Each respondent claims, among other things, that the government would violate their due process if they didn't have sufficient notice about going to this new country that they just pull out of their butts. Soon after filing their complaint, they then got certified as a class. They filed a preliminary injunction. Respondents then moved for a TRO. The lunatic judge granted it. The First Circuit declined to stay, and now here we are. Then on April 18th, the lower level judge granted their motion to be class action gangbangers and said everybody has to stay. The court first held that none of the jurisdictional bars apply. The judge says, well, I can do whatever I want in this case, and then revised the entire policy, changed everything that Homeland had set up. The First Circuit got the government request, didn't care. During this time, the district court also intervened and said, don't remove these people to third parties either. The government developed a bunch of additional procedures and removed them. We were in compliance with this judge's order. So we executed the removal, initiated them, sent them to the South Sudan. All of them were provided notice that they would be removed. All of them. None of them expressed any fear of being removed there. But that's only because they didn't have time to talk to the lawyers. The lawyers would have made them have a fear, you know? Now, here's another statement. All of these aliens have committed crimes. crimes, heinous in the United States. Unaliving people, arson, robbery with weapons, kidnapping, assault of mentally handicapped people, children, and more. But the judges love them. Moreover, because there are limitations on what we can do, some of these aliens were forced to be released previously forced to be released, which is what they want. They want them running around in the country, crashing into your daughters, eliminating them. Tragically, but predictably, some aliens then committed further crimes in this country. Yeah, such as one was convicted of attempted murder after his release, but they don't care. Respondent sought emergency relief, says, hey, you're sending our class gangbangers to the South Sudan. Filed their motion. The judge came back out, granted it. The next day, the court said, hey, you violated my injunction. They were not given enough time to raise their claims. The court said, well, I clarified this all, and meaningful opportunity was not like hours, which is plenty of time. Are you afraid? How long does it take you to figure that out? 10 days? Like you need to sit on it? You need to read some books and journal on it? Go like on a long walk on the beach, use alien, pray about it. Am I even claims against torture? Ridiculous. As for the aliens in the process of being removed, who were and are being held at the military base in Djibouti, then they said, you got to take control of these people. And we read this earlier in a prior show, that the government must give them all an interview in private. They must ensure that they got 72 hours notice of that interview. They must get commensurate resources that they would have gotten in the United States. And of course, they're going to want the lawyers to appear on those. Now, they say, this is ridiculous, Supreme Court. We're going to win on this, and you need to do something. This injunction that came down from this lower level judge exceeds his authority in numerous ways. First of all, the injunction violates the plain terms of the law of multiple jurisdictional bars. The INA that was not passed by Trump, it strips this court of jurisdiction. They can't issue these class-wide injunctions. One, they can't review claims that the government came out with after an interview or an analysis of claims against torture. Two, and they can't even adjudicate suits that are coming up from these removal proceedings. But the judge is doing all three of these things. All three are prohibited and effectively overrules the INA, which is what we're following. But in addition to not even having jurisdiction, this is kind of insulting to this judge, the merits analysis was also wrong. Like, first of all, he's an idiot or dishonest, unethical judge because he shouldn't even be hearing this case, but he violated 3 rules in order to do that. And then when he did that, his decision is also idiotic. The March guidance that Homeland created gives way more ample process than even necessary. They got notice, opportunity to be heard. These people were already ordered removed, and they already had a chance to raise their claims. Okay, so by the way, this is a second attempt to raise a new claim. They've already had it, already been done. So again, like you go, you fight your speeding ticket because that cop's a liar and he didn't get you on his radar gun, and you lose, you complain, your due process rights were violated, and the judge gives you another hearing in a more favorable court, in fact, and gives you 15 days to go meet with some amazing lawyers who are going to come in and help you do that. You get those privileges? No, because you're a citizen. Who do you think you are? The district court's decision to augment those procedures was policy making, not law. He's not allowed to do that. The Constitution assigns to the political branches the authority to design the laws and to decide what due process is due to those that violate them. They're not citizens, not even close. And the intrusion here is all the more intolerable because it disrupts sensitive diplomatic foreign policy and other national security interests that we're in charge of. And they give us more meat on these potatoes. As you can see, great details here. This class-wide injunction is illegal. 3 reasons that we've talked about. This case forbids this, and this case does too. Now, in addition to the other order, it also violates claims against torture bars. No court shall have jurisdiction to review our decision. You can't substitute your judgment for Kristi Noem's because you're not Kristi Noem. The injunction runs afoul of these limits, and the lower level judge just ignored it, didn't even care, ignored it, and concluded that he can do what he wants and did what he wants. But he doesn't have jurisdiction and is misreading the entire statute. Now, in addition to the lack of jurisdiction, their other claims are terrible. Even if you say this judge doesn't have jurisdiction, or even if you say he does have jurisdiction, he's still going to lose this thing. The procedures for implementing the claims against torture process were totally valid. All class members here, by the way, all have final orders of removal. It's done. They had their trials, cases are closed, they could file their claims for withholding or asylum or claims against torture or whatever. They had their shot, they didn't take it, it's done. All had the opportunity to raise these in their prior proceedings, voice any fears, and they didn't. The March guidance explains that the government provides these aliens with additional processes before they're actually removed, so we do it again in some way. The process is detailed below. It ensures an alien is going to be sent to the right country. We're not going to send them where they're going to be tortured. But the district court second-guessed everything and said, I don't like what you've done, and I'm going to substitute my judgment. Now, as noted, the March guidance says very clearly from Homeland, an alien may be removed to a country that has provided diplomatic assurances that aliens will not be persecuted or tortured. If the State Department finds that that's credible, that's the game. The alien may be removed without the need for further procedures, okay? If they find that country is safe, their diplomatic relations, they're not going to torture you, you've already had your claims against torture, and it's a new country. Great. We're done. You got everything you need. The Constitution requires nothing further. Indeed, this court has already held that, saying when the executive determines a country will not torture someone, that is conclusive. Hey, Supreme Court, pay attention. You said that back in 2008 in Munaf versus Guerin in the U.S. Supreme Court. And the D.C. Circuit also said that in 2009. They said federal courts may not question the government's determination that the recipient country is not likely to torture a detainee, because the courts aren't set up for that. The executive branch is. So they don't get to substitute their, well, I think the South Sudan is bad, or Nayib Bukele out of El Salvador is bad, or it's not your prerogative, Judge. You don't get to make that decision. You're not in the Secretary of State's office. Now, the district court at the lower level disagreed, said, well, I still want to do something here. It insists that you have to individually assess every single person and that you have to interview them one at a time. But this is not procedural due process at all, okay? This is not saying your process is bad. No, in fact, it's substantive due process. It's saying that you need to give them due process plus in America, and we don't have to do that. And what the judge did is irreconcilable with other Supreme Court precedent. But our proceedings and our process was perfectly constitutional. They offered no basis in law for any constitutional dictates that say we have to follow them. Like, where'd those come from? Where did the 10 and the 15 days come from that is suddenly now due process compliant? The judge just made it up out of his butt. To the contrary, they are inconsistent with established immigration law. Most analogous are other proceedings, and we're allowed to do this in other proceedings, but the district court didn't care about any of that. Hey, why is this case being treated differently than everyone else? He says, well, because my sense of fairness requires it, and I want them back in my chambers. Nor does the district court's preferred policy even make sense on its own terms, right? The injunction says all class members have to get at least 15 days to move to reopen proceedings after an adverse reasonable fear finding. Okay, so you say, I'm afraid. They say, no, you're not. You're not going to get attacked with your papooses down there. Calm down. 15 days to challenge that. The government, they say, when we make an individualized assurance, we still have to wait? Hold on a minute. So then you're saying we have to talk to them and do like this really deep analysis and then wait after that? So what's the point of doing the thing? But if the government opts to take that course, the injunction still requires 2 weeks to do this. It is new. It's novel due process requirements. They just made it up. It shouldn't come from the courts. Not allowed to. It comes from the executive branch. For aliens who've never been admitted, the decisions of the executive are all acting within the powers of Congress. That's who has the power to do it. Now, to this end, this court, the Supreme Court, has also applied the so-called entry fiction that all aliens who arrive at ports of entry are treated for due process purposes as if being stopped at the border. And this is indeed even in other places where they've entered and been here for years pending removal. The court has applied the entry fiction to aliens highly sympathetic in their claims to having entered, who have had significant ties to this country. But here they say this court's precedent indicates that illegal aliens who evade detection in crossing the border should be treated the same as those who were stopped at the border in the first place. You don't get some benefit of the doubt because they broke in. Congress has codified a distinction by treating all aliens who have been admitted, including unlawful entrants who evade detections, as applicants for admission. Now, that rule comports with the Constitution, and the Due Process Clause, there it is, does not provide a windfall for those who successfully circumvent our laws. They got notice that they're in the country illegally, they broke in illegally, they can't claim ignorance now or something. It doesn't matter whether they were apprehended 25 yards into the territory or 25 miles into the territory, whether they evaded detection for 25 minutes or 25 years. They're not a class. They're all differently situated. And the Due Process Clause of our Constitution that they don't give a crap about does not give these aliens a constitutional entitlement to extra removal procedures beyond what's already been codified in the law. But that is precisely what this lunatic judge does. Again, the INA is silent as to any specific process that they must be afforded. The March guidance is the political branch's reasoned judgment as to what is valid, and it's not arbitrary. It's perfectly in alignment with all the other case law and precedent that the Congress has actually passed in statute and that the Supreme Court has handed down. The Constitution requires nothing further. We provided aliens ample process to validate invalidate their rights. And so you got to hear this case, Supreme Court. This injunction interferes with the executive branch, and you're intervening in a bunch of other cases here, right? We're knocking on the Supreme Court's door. You got to do something now. Like, enough of this game. It says Trump versus Wilcox. Trump won that one. Nome versus National TPS Alliance. Suck it. She won that one. Trump versus Sierra Club. Granting a stay of other cases and INS and more. This is 1993 case back from O'Connor. Now, the same course is merited here, Supreme Court. You've acted to stop all that other insanity. Now it's time to do this here. Trump has determined that the millions of illegal aliens who have been released back into the United States present an immediate threat to our nation, and he has acted accordingly. Now, to combat this, the administration has engaged in, quote, an unprecedented effort to remove the illegals. And in turn, we've developed our policies to strike a balance between providing adequate process while ensuring that overdue expeditions in removals are happening. Now, the government is going to suffer irreparable harm if you don't act. Anytime our policy is blocked, that's an irreparable harm. Okay, just to be clear. Just so you know, John Roberts, you said that. Anytime a government's policy is blocked, that's a harm to the government. That harm is happening now. And they're particularly pronounced in this case, John Roberts. While the Constitution envisions that the political departments will be immune from judicial control in the immigration sphere, that's what the law says in 1977 case, the district court's injunction is the opposite. The judge is now superintending illegal alien removals. And as the episode with the South Sudan confirms, the injunction's open-ended terms allow for this judge to do whatever he wants, continually revise and reinvent his policy to serve his ends. Now, the court has indicated the same. He says, yeah, further things are going to change. Get ready for it. This is unworkable, Supreme Court. It was problematic enough for the court to write its own procedures, but it's simply untenable now for that project to be a work in progress where they continuously move the goalpost time and again. Now, the practical consequences of this underscore why the Constitution assigns immigration policy to the political branches, not to district court judges. As noted, this court's policy gives illegals 25 days worth of delay for every alien in the country, and they're all going to start filing claims, regardless of how frivolous the claim is. We've seen this with Papusa, Gang Boy. Because ICE often has only a short window to remove these people, these documents are not valid indefinitely, and this is going to scuttle the entire removal process. These operational burdens are high, and worse, the injunction has harmed foreign policy. Rubio explained this too, saying arranging a removal to a third country is a very delicate and diplomatic issue, and we had to stop in Djibouti, which is having serious consequences with the DOD and more. There are also severe costs in service of any public benefit as well. The United States has to send these people to third parties because their home countries won't even take them back. Absent an effective third-party removal policy, these vicious criminals have to stay in our country, which is what they want. The aliens sent to South Sudan are convicted offenders and unalivers. It is illustrative of the broader problem happening all across the country where our people are being killed. On the other side of the ledger, what is their harm? Well, the secretary already has assurances they're not going to be tortured, and they never made their claims in the first place, and they didn't make their claims in the second place either after we asked them again. So what's the harm? Neither the district court nor the gangbang lawyers have responded or identified any irreparable harm, nor could they, because their decisions are all on the same basis. They say no alien is going to be tortured. Any requirement for an individualized determination would identify that. Now, likewise, for aliens set to be removed to other countries, they had ample opportunity to raise their claims, and they've never justified why these added measures, like the 25 additional days, are going to forestall any irreparable harm. Now, that's especially so. There's no realistic risk that they're going to be tortured, and everything that we did was perfectly acceptable. And so, Supreme Court, if you're there, wake up. The Supreme Court should stay the district court's injunction. Stop this. The court should also enter an immediate administrative stay of the district court's injunction pending its consideration of this application. So, signed by D. John Sauer, and the Supreme Court could do something about this. We got an appendix and all the other lower level rulings, including from this judge, Judge Murphy, who is very unhappy with a lot of this stuff. Up to the Supreme Court, Pam Bondi, Chad Mizell, very nice filing, and it is getting frustrating to see our Supreme Court not doing anything about this while we've got Americans being killed by illegals. And apparently they get more process than she does. And Amy Coney Barrett and John Roberts and their shifting standards for accepting cases is causing more of this to happen. And hopefully they act. We're going to keep our eye on this case. Thanks for subscribing and joining as we do.